Gentleman yields back. Now recognize the ranking member of the full committee, Mr. Pallone, for his 5 minutes of questioning.
Thank you, Chairman Bilirakis. Data brokers collect and sell billions of data points on nearly every consumer in the United States, including children. And while I believe that comprehensive privacy is the preferred path to addressing the risks of data brokers, I also believe it's imperative to do what we can now to prevent data brokers from exploiting the personal data of our kids. So I have a series of questions for Ms. Ruane. If you could just answer them quickly, because otherwise I won't get through them. First is, why is it so important that kids and teens are able to enter adulthood without an extensive profile already built of their online activities and inferences about who they are?
Thank you, Ranking Member. Well, kids are growing up online, right? They are sharing all of their information all of the time. They are engaging constantly, and their data is also being collected constantly in ways that they might not understand or even be aware of or be developmentally capable of making decisions about. They don't know they're making a trail that's going to follow them forever. But what's most important is that children are not commodities, and their lives and privacy have to be respected. Ensuring that their information cannot be bought and sold by shady data brokers will meaningfully protect their privacy in general and their ability to enter adulthood without a profile that will follow them for the rest of time.
Well, thank you. Now, many of the bills being considered for this hearing today contain broad preemption clauses, and in many cases preempting any state laws that relate to the legislation. So the next question is, what are some unintended consequences of such broad preemption? Could common law and product liability claims currently being used to hold tech companies accountable be impacted by that?
Yes, absolutely. We are concerned that currently extant state protections that protect everyone will no longer be able to protect children across all 50 states. One other thing to note is a lot of the bills today focus on legacy platforms and services that have existed for a while, and they do not focus on emerging technologies like generative AI. If we institute a broad relates to preemption standard across all of these bills, we run the risk of preempting states' ability to act on emerging technologies quickly.
Okay. Many of the bills being discussed today also have provisions that expand access to the data of teens, both to third parties and to parents in the name of increased safety. And while I encourage parents and teens to have conversation about teens' online activity, that also needs to be balanced against teens' rights to privacy. So as we consider the bills before us, how do we best balance privacy and safety? Are there any specific provisions in these bills that pose a threat to kids' privacy?
Absolutely. Parents and kids, families, need tools to help them navigate their online lives, and CDT fully supports giving parents those tools and children those tools. But we are concerned about any provisions that give parents access to and control over the content of kids' communications. One thing that KOSA, that the current version of KOSA does well, is it ensures that parents and that platforms do not have to disclose the contents of kids' communications. But today's new version of KOSA, of COPPA 2.0, for example, contains language that might allow parents to delete their kids' data and to delete content that they may have created. When we talked to parents and kids about whether they wanted to have those sorts of tools, parents told us that that seemed overly burdensome for parents, and kids told us that seemed overly invasive to them. Moreover, as you noted in your opening statement, not all kids are growing up in families that are perfectly supportive, and some kids are growing up in situations where they don't have families at all.
Well, that's sort of my last question, because
Yeah.
I know we're going to run out of time. But unfortunately, the reality is that there are parents who abuse or neglect their children, and for these kids, access to safe spaces online can be critical. So the last question is, how do we foster healthy connections online while ensuring that kids and teens are protected? Are there potential risks to children and teens in dangerous or hostile family environments caused by the measures in these bills?
Well, when we talked to teenagers about how they use, for example, direct messaging services, they told us that what they really want are more controls over who gets to message them. So the ability to reduce their own visibility online. Congress could also incentivize more friction or speed bumps in interaction with kind of unknown profiles or unknown adults. We also took note that one of the bills today would restrict access to ephemeral messaging. Now, while it's understandable that in some circumstances ephemeral messaging could be linked to harm, we also want to note that it could also be used to protect kids' privacy. So, for example, children might communicate with each other, teens might communicate with each other through racy text messages. Ephemeral messaging could reduce the likelihood that those messages be used for abusive purposes like non-consensual intimate image distribution at a later date. Ephemeral messages could also be helpful for children who have relationships with domestic violence victims or who are domestic violence victims themselves to ensure safety and to ensure their ability to communicate privately without risk to their physical harm, to their physical selves.
Thank you, Mr. Chairman.
Thank you very much, and the gentleman yields